Either Chittaranjan Kamat, Chittaranjan Manti, Bright Power, regular product. All the ones that are used in discussion.
From the main list, item number 1.
Not ask this is not
Appeal against.
Order of the learned signatures, my lord.
What is the matter about?
This is about pension to a deceased employee of Assam Rifles, my lord.
Pension to a?
To the wife of the deceased employee.
Family
of
pension.
My lord, the husband of the respondent, my lord, died in the year 19. Was discharged from Assam Rifles in the year 1950.
50?
50, my lord. They came before this honorable court in 2016, my lord. And the primary plea we took that we don't have the records because it's 65 years down the line, all the records, because there's a time limit for maintaining the records of 20 years, my lord. And it's very belated. The learned single judge has allowed that partially, my lord. From 3 years from the date of filing of the writ petition, we've come against that, my lord.
3 years from the date of?
Filing of the writ petition.
So 3 years prior to that?
From 2013, basically.
How old is this lady?
She must be 90 plus now.
90 plus.
You're sure the husband was there? and was discharged.
My lord, what happens, we maintain record for 20 years and after that we destroy the records and we prepare a brief sheet, my lord. One sheet of basic information.
So what does that brief sheet show?
My lord, the brief sheet shows that he was there in Assam Rifle, my lord, and during Second World War he suffered some kind of ear impairment, my lord, because of bombardment. And on that count he was discharged from service.
Make an exception. This will not be treated as a precedent. We'll set aside the order, but you agree to pay. We'll set aside the order.
My lord, what happened during the proceedings, my lord, taking a very lenient view, I advised the department, my lord, an ex gratia of 1 lakh rupees was paid, saying department consider from their welfare fund, they paid the amount of 1 lakh rupees.
No, but in the usual course,
My lord.
if an employee was discharged,
My lord.
that employee would be entitled to pension. His wife would be entitled to family pension after his death.
My lord.
When did he die?
2010, my lord.
2010. So for such a long time, he did not take pension.
My lord.
For whatever, he did not take pension. So a lot of money has been saved. He was not discharged dishonorably. He was discharged because he was
Invalidity, my lord.
because he suffered some kind of. If you insist, we won't interfere. But so that this does not create a precedent, take instructions,
My lord.
pay her the same amount as has been directed,
My lord.
give her a letter as a special consideration. We'll set aside the order and say the matter has been resolved.
It comes up next week sometime.
Come up next week because you must make a cost-benefit analysis. After all, the man is entitled, and this is where no limitation really runs that way.
My lord, in fact, that was my opinion to the department. They still insisted on it.
No limitation runs.
I'll take instruction. I'll talk to the department.
This is his entitlement and her entitlement now.
Your Lordship, we have been verbally instructed to appear on her behalf, Your Lordship. And
Sorry?
We are verbally instructed to appear on her behalf, Your Lordship, just yesterday only. So we are yet to file
Very
the
good.
Wakalat Nama. So in the meantime, we'll file the Wakalat
Do
Nama.
it. It'll come up next week. Do it. When should it come?
7th, my lord.
Very well. Since it appears that the matter may be resolved internally by the Assam Rifles, let the matter appear a week hence and give.
7th.
Yes.
Item number 2.
Where are we, Mr. Khan?
Lordship, it's the stage is for serving the copy of the affidavits to all the respondents
Yes.
as per the order, Your Lordship. And so we have served almost to everybody, and we made some extra copy because, Your Lordship, some of the respondents' counsel is not available then. So we made an extra copy. If somebody wants a copy, we can serve it in the course of the day.
Because you also indicated to you tentatively as to what the quantum of compensation is going to be. So we just need everyone to be on board and then to put forth their suggestions. We'll determine the quantum as indicated and then you will have to ensure that it reaches everybody. There is no other issue anymore, Dr. Mazika?
My lord, there are two aspects, my lord. What I could 38 names I prepared a synopsis of in what circumstances they died and where they died and what was their age and what were the cases against them, my lord. And after that, they've given 11 other names. So I prepared a synopsis of that also, my lord. So as of now, we have 49 cases of deaths in custody.
At least we are agreed on the number, Mr. Khan. 49.
49, my lord.
And all of them would be entitled to compensation.
My lord, majority of the cases are suicide in prison, my lord. Hanging, some in police custody also and some in prison, my lord.
So your Lordship points me, my 2 cases, they are shown to be suicide, but this is in fact not suicide. I'll substantiate that.
Even if it is not suicide and we can't probably start murder charges now, but suicide and murder will amount to the same compensation. Because they were responsible for your body.
They are responsible.
So if you've committed suicide or if because of their torture you have succumbed,
Yes.
both will be compensated the same way. So that distinction you need not make, but we probably cannot institute murder charges now.
But Lordship has rightly said, I mean, one of the larger issues involved in this particular case, Lordship, would be, as suggested by the amicus, that if you go to the ministerial inquiry, Lordship, if the contributory negligence, like in case of torture, then the liabilities directly falls on the state, Lordship. That would be an aggravated form of compensation. But in case of unnatural death, it was caused because of supposing the cell was not kept properly.
That is driven by torture. And as long as you ensure that the person does not, you drive him up the wall and you give him the tools by which he can hang himself, same thing.
So, ministerial inquiry in each case has to be, at least the chaff from the grain has to be separated.
We will do that, but we will treat murder and suicide on the same level. Suicide in custody is the same as murder.
So we'll have to go through the evidence at least on that part.
We will go through it.
My lord, since the synopsis I prepared, my lord, I've indicated
It's only when
if the government can themselves consider, my lord, on the basis of the report I prepared, my lord.
yes,
They can come
it's
up with
only when it's absolutely, he suffers a heart attack. There's no sign of injury or otherwise had a history. Those cases we will.
Absolutely, Lordship, yes.
Those cases we will delete.
There are some cases.
There are some cases. Lordship
There are some cases. Those
Lordship
cases
has rightly
we
pointed
delete.
out. In fact, those are the cases which have to be an
We
exception.
delete. But if you do the exercise based on Dr. Mozika's inputs, then we don't have to do it. And if you do the exercise, you'll probably have less payout than if you make us do the exercise.
Absolutely, Lordship. Lordship is correct. The government is still under consideration, in Lordship. After the order passed by the court, government is under consideration. Slight pause because of the change of the government and election, in Lordship. But government is under consideration for this because this has got long-term effect.
Yes.
And then it has rightly fallen from the court, Lordship. If the court takes a judicial notice of it, then things government could have done on its home.
It'll be much worse when the court decides.
Absolutely, Lordship. Yes.
The state and Dr. Mozika, amicus curiae, are agreed that the number of deaths in custody since the year 2012 is 49. Full stop. Paragraph. While the state maintains that several, if not most, of the deaths have been due to natural causes, the postmortem and other reports, according to Dr. Mozika, indicate otherwise, except in a few cases. Full stop. The state also submits that a distinction ought to be made between deaths that may have occurred unnaturally without the person committing suicide and those who actually committed suicide and the postmortem report reveals as such. Full stop. Paragraph. There is no reason to elaborate how death can occur unnaturally while a person is in custody. Full stop. It's the similar cause that may drive a person to suicide. Full stop. As such, in principle, no distinction need be made between death in custody, between unnatural death in custody, whether by suicide or otherwise. full stop. However, comma, the state is left free to put forth its submission in such regard. Paragraph, several of the heirs or next of kin of the persons who suffered custodial death in the state since 2012 are represented, full stop. The state says that the heir or family members of all of the 49 persons have been attempted to be served, comma, but the addresses of a few of them are not available, full stop. The state appears to have published advertisements. You published advertisements. Appears to have published advertisements. Full stop. The state will make every further endeavor to ensure that the rightful persons are made aware of the present proceedings and the compensation that they may receive. Full stop. Paragraph. The state assures the court that the matter is under its active consideration and the state may itself take a decision with regard to the compensation payable, subject to the death being attributable to the police or the state, full stop. Paragraph, if the state conducts the exercise itself, based on the inputs given by Dr. Mozika as to the reason of death in each of the 49 cases, as long as the quantum appears reasonable, the court may allow the matter to rest, full stop. Paragraph, however, if the court is required to take up the exercise, the quantum of compensation may be considerably higher. Full stop.
Keep it after 2 or 3 weeks further.
Paragraph, the matter will appear 3 weeks hence.
Also, a small submission.
Yes.
The observation made earlier by this court regarding the quantum, if that may not come in the way, while
Which
state
one?
is stored, this honorable court made some observation regarding the quantum. So while state considering if that may not come in the way.
No, but that's a ballpark figure we've indicated. You cannot give 2 lakhs and 20,000,
But I said like for consideration it may not come in the way.
It will not. It will not. But we've said it has to be unreasonable. So we'll go by the reasonableness of that.
But that order is already in.
It won't come in.
Oblige.
Item number 3.
May it please your lordship.
Yes, sir.
Before I give my submission, my lord argument, I also seek permission of your lordship to provide a copy of written argument,
We don't need.
my lord.
Tell the Supreme Court we threw it away.
Your lordship,
Tell the Supreme Court we threw it away.
my lord. My lord, now the factum of the case is, my lord, The appellant was enrolled in the Assam Rifle on 25th May 1987 to the rank of Lance Naik Writer.
Rank of
Lance Naik Writer.
Lance Naik Writer.
Writer. And in 1997, he was promoted to the rank of Havaldar, clerk.
When was he enrolled?
Enrolled on 25th May 1987, my lord.
Yes, continue.
As Lance Naik Writer. And then my lord promoted to the rank of Havaldar clerk in 1997. Now my lord, in 2001, he cleared the Departmental Promotion Examination Commission to the rank of Assistant Commandant.
Rank of assistant?
Assistant Commandant. In 2001,
Commander.
Assistant Commandant, my lord. He cleared the examination, direct examination for the promotion of Assistant Commandant, and in 2001. And after undergoing training at Indian Military Academy, in 2003, on 25th May, he was commissioned as an Assistant Commandant.
Commissioned as Assistant Commander.
Assistant Commandant, my lord. My lord, he has performed his duties since very beginning, till date, my lord, to the best interest of the organization and to the best of his abilities.
Yes. So what is your grievance?
My lord, my lord, one more point, my lord, just small point. And he has been awarded Gallantry Award Sena Medal on 26 January 2010. Then he has been awarded Chief of Army Staff Combination Card twice. He has also been given Director General Assam Rifles Combination Card thrice in his career. And he has also been given Governor's Gold Medal for his outstanding performance in the administration of the regiment. And in 2017-18, my lord, he has pursued the Memorandum of Understanding, and on 27th December 18, my lord, a Memorandum of Understanding was established with the government of Manipur for KCP PWG outfit to shun the violence which was achieved, my lord. That was major landmarks in his career profile. Now, my lord, I repeat, in his entire record of service, he has never been counseled, warned for wanting in services or his responsibilities or duties. He has never been informed or communicated in that.
No adverse remark communicated ever.
No adverse remark, my lord, nor any counseling has been communicated to him throughout his service.
Yes.
And he has been assessed in his performance, my lord, as outstanding, near to outstanding, and high average. My lord, this also, your worship will find in this supplementary affidavit, your worship, that Annexure SA 3, this, which was, my lord, there with the case number, my lord, 17 of 22, my lord, from page 27 to 38, my lord. His pen picture I have added, my lord, his pen picture I have noted, starting from page 28, my lord. Now, throughout this, my lord,
This is prepared by you.
my lord, this is of respondents, my lord, copy of the documents of respondents, my lord.
Page 27.
Page 27 is prepared by us.
Yes, that is
Page
your,
28, my lord, page 28, 238, my lord, is the document of the respondent, my lord.
20.
8 to 38, my lord. It is a document of the respondent, my lord, from the annual confidential reports. This is also on your worship record. For easy comprehension, I have summarized it, the pen picture, my lord, written by various officers in the chain of reporting.
Yes.
It is commencing, my lord, this has been provided to me on 13th of January 2020, my lord.
Which one? This from page
The
28?
entire thing which is there contained in this,
From page 28 to page
238, my lord.
38.
It was provided to me, my lord, on 13th January 2020.
Yes.
Now, my lord, as per the respondents, my lord,
What is your grievance? What is your grievance? What is the relief that you...
I'm just coming, my lord. I'm just coming, my lord. Just coming, my lord. Give me some friction of second, my lord. My lord, in 2019, my lord, on 13th October, 14th October, my lord, 14th October 19, as per the respondents, my lord, Departmental Promotion Committee was established, set up to consider the eligible second in commands to the rank of commandant. And in that, my lord, this document contains at the page of the appeal paper book of page 262 to 66, my lord. Appeal paper book, my lord, page. The DPC was held page 260 to 261, my lord.
Page 260?
To 261 is the proceeding of the
DPC.
at page 261, my lord. My name is appearing at serial 5.
Yes.
And at page 263, I have been made unfit for the promotion due to lack of benchmark ACR grading for the assessment year 2015-16 average
63,
instead
yes.
of very good.
Just a second. 263. Where is your name?
My lord, my name is at page 261, serial number 5.
No, that we found.
Then page 263, my lord.
262 last name.
63, my lord.
262 last name.
One ahead. Yes, last.
Para 10, my lord.
Yes.
Yes.
Your worship found it.
Yes.
My lord, serial para 8, your worship, para 10, I have serial 5. I have been made unfit solely because of the report of 2015-16 that has been assessed as average.
Very good.
My lord, 6 to ICs were second in commands were selected, my lord, out of 8, and I was rejected into that, my lord.
Yes.
And thereafter, my lord, after this board was held, the annual confidential report from 1st April 2009 to 31st March 16 was supplied to me, which was it? That is, my lord, page 71 of the paper book, my lord.
When was this applied?
My lord, it was supplied by letter 29th November 2019. After the DPC was held, my lord. On page 71 of the paper book. And received by me, my lord.
Received on 13 January 2020.
13 January 2020, my lord. Next page, my lord, page 72.
Yes. Which is the same as 28 to 38 that you showed us.
Yes, your worship. Now, my lord, from this, my lord, it was learnt that the CR, which I have annexed, my lord, my lord, supplementary affidavit. Now, your worship, this ACR is at page 35 of my this supplementary affidavit, my lord.
Yes.
My lord, if your worship sees page 35 and then comparative perusal of page 28 and 238, my lord. With the comparative perusal from the page 28, that is confidential report commencing 2009-10 till, my lord, this is the other one is the 2018. That was considered by DPC, my lord, 38, my lord, page 38. This impugned ACR, my lord, is inconsistent with the overall profile of the petitioner, my lord. It is wholly inconsistent. During this period, I have been assessed as an asset to the organization, indispensable to the organization, exceptional in performance of my duties, and this year I have been assessed as an average person, which is inconsistent with my previous and subsequent to career profile of the petitioner, your worship.
Yes.
Now, my lord, this is inconsistency has affected me, my lord. Now, your worship, again, if your lordship sees, permit me, my lord, to bear with me to go through. It is written by the initiating officer that second in command M.A. Farooqui is an average officer. He is performing the duties of second in command of the battalion and also looking after training. The officer has a lot of scope for improvement of professional life. The work assigned to the officer needs to be monitored closely to achieve the desired result. He is happily married. Now, my lord, see the reviewing officer's remarks, my lord. Farooqui was a mature second in command of 36 Assam Rifle, who understood and remained updated on the counter-insurgency situations in area of responsibility. He had been officiating a number of times while the commandant was away, and I found him quite stable in his dealings. He has always been organizational and delivered to the best of his abilities. Required guidance on few occasions on operational matters, but thereafter could be trusted with responsibility. Now, my lord, this DIG-AR, his writing, Farooqui is second in command of 36 Assam Rifle, performed, initially he has written, my lord, the hand above average, now he deleted, he cut the average above. Now he was verbally counseled by me in April 15 in April 15, my lord, by the commandant and by the commandant 36 Assam Rifle on 8 April 15. Here is specific, my lord, that he was counselled on 8 April 15 to improve his interpersonal conduct with officers and JCOs /OR being a permanent low medical category. His contribution to city operation was limited. Now my copy of warning letter issued by Commandant 36 to the Assam Rifles, white letter number this is enclosed. 8 April is enclosed. Now my lord, it is written by SRO, IGAR, my lord. IGAR, my lord, not SRO. Farooqi is a sincere and hard-working officer who was following correctly, always correctly turned out. As second in command, he contributed positively towards training and administration of 36 Assam Rifles. Then, my lord, the senior reporting officer writes, a sincere and hard-working officer who has performed commendably, my lord. As second in command of the battalion, in all facets of training and administration. My lord, commendably cannot be average.
Anyway, what is your grievance?
My lord, if it is compared, firstly, it is.
Please tell us now, we've waited a long time. What is the infraction?
My grievance is, my lord, this letter which has been quoted has never been communicated to.
Forget that. What is the infraction? Where is the law that they're required to supply it to you? Where are the rules? Tell us this rule has been violated. We are able to appreciate better.
Yes, Your Worship. Kindly have page 270 of paper book, my lord. Your Worship, kindly come back to
270.
My lord. Page 270, my lord. Annexary.
Type copy of this. This is one page.
This is letter, my lord, dated 14th May 2009.
14th?
May 2009.
Yes.
This, my lord, this is office memorandum of Department of Personnel and Training. It mandates, my lord, the existing nomenclature of the annual confidential report will be modified as annual performance assessment report. The full APR, including the overall grades and assessment of integrity, shall be communicated to concerned officers after the report is complete, with the remarks of the reviewing officer and the authenticating authority, my lord. This ACR, my lord, which has been considered.
Just a second. Where are you reading the full?
Is in the bottom.
Second, my lord, Roman second, paragraph 2. If your worship turns over the page 271, such communication shall be made after the reporting officer has completed the performance assessment.
No, that is in case of only one level of assessment.
Yes, my lord. Now, if there are two, it has to be communicated after the endorsement has been made. Now, third is, my lord, the section interested with the maintenance of APR, after its receipt, shall disclose the same to the officer on the my lord, reported upon.
Should be officers.
To the officer reported upon. Then the concerning officers shall have opportunity to make any representation against the entries and the final grading given in the report after a period of 15 days from the date of receipt of the entries of APR. Now, my lord, this ACR, once it was initiated, has never been communicated to me at all. Now the respondents have relied. Appendix F.
They have relied on?
Appendix F, my lord, page 272.
Yes.
Saying that first time they had a knowledge of this letter It is copied to given, my lord, to all concerned. Your worship, page annexure E, my lord, what I have read is the 268 is the, my lord, type. This is the original copy, and this is there is a typed copy. 268 and 269 is the original letter, my lord, filed by the respondent. Now the copies have been provided. Now, my lord, if your worship sees, it says that the undersigned is to direct to refer to this letter number so and so, 14th May 2009, and the subject above, and in spite of guidance was issued on the so department of Ministry of so and so, the communication of all entries in APR for fairness and transparency in place of administration, it has been observed that this thing is not being abided by, leading to unavoidable litigations. And they were informed, it was reminder issued to them that you are not abiding, and copy was to the DGAR also, my lord.
So what has been held
My lord?
against you? Let us see the judgment now.
Now, my lord, the order of the Honorable Single Judge, my lord, 351 page, my lord. Para 18.
Just
It says the petitioner was also
just a second.
351, my lord. It says the petitioner was also served with a warning
1
letter.
minute, just give us a minute, please. Yes, Mr. Devnath. Is it the admitted position that he received the papers only on 13th of January 2020?
Your Lordship, this as a ACR.
We've asked you a simple question. Yes or no? Thereafter, you can say whatever else you want.
Yes, Your Lordship.
So, how did he have a chance to make a representation against it? If you are going to make an adverse remark against me, then I ought to be given a chance to make a representation. He was not given it. He was denied the opportunity of making a representation, and you considered his case and found him unfit on the adverse remark that you had made, and you had not given him an opportunity to contest.
Your Lordship, in this matters of this sending the ACR for as a whole of the Assam Rifle people, officers together. So it has been done in 2000. This is correct position. It is
So therefore, it has to go.
So, Your Lordship, in this case, in the particular case, Your Lordship, what's happened here in this ACR, he has himself is even authenticated this is correct.
He has himself?
He has not authenticated, Your Lordship, in my affidavit. Your Lordship, I've given here in Annexure 1.
Affidavit filed before the writ court.
Yes.
Where is it? In the paper book?
In the paper book also there, even it is in the my affidavit also. It will shorter in my affidavit, page 20.
Page?
Page 20.
Page?
20. Annexure A.
Yes.
So this is his acknowledgement about his ACR, Your Lordship. So he cannot say that he is not having knowledge about it. And none of them was communicated separately. This is the
This signature and date is 1st April 2016.
yes, Your Lordship. This is the, for the year 15-16. So this is the ACR prepared, and it is authenticated by the writ appellant himself.
How do you deal with this?
So, Your Lordship, it was having knowledge of the
No,
appellant.
just a second. We have to give him a chance to indicate. That's why I have a vague recollection that we were against you the last time. This is the reason. Why have you not written his name in the order? Why have you not written his name in the order? He's appeared at least 2 times before. Why does his name not appear in the order sheet? Even that we have to hold your pen and write it for you? Yes, how do you explain that document?
Me, my lord.
Yes.
My lord, submission is, my lord, this is incorrect. What I have stated in the petition is that on 1st April, if your worship sees Annexure A,
Yes.
on 1st April, the medical was carried out, my lord.
On 1st April,
Medical was carried out, my lord. On 1st April, I have submitted this form to the office. Number 2, my lord.
now this has been disclosed in their affidavit.
Secondly, my lord.
You have
yes,
filed a rejoinder. How have you dealt with it in the rejoinder?
I have said in
Where have you dealt with it in the rejoinder?
sir, it is para 4. My,
Rejoinder, para 4.
no, my lord, just a second, please. My lord, the rejoinder is, my lord, that the contents of para 4, my lord, rejoinder page 5.
Rejoinder.
Para 5, my lord. The opposition are incorrect, twisted and distorted, has denied as stated, and contents of para 1.3 of WA appeal are
Forget your lecture. Forget your lecture. Rubbish. Come to page 20.
Your worship,
Have you denied your signature at this page?
signatures have not been denied.
Then
What
there is
has
a
been-
date, there is a signature,
It is my signature.
and it is your date. Now you have to explain.
Yes, my lord,
Where is your explanation?
See, page 25 is signed with you.
20.
25. Average is communicated on tongue.
Where have you dealt with in your rejoinder? Also come to page 25 of that affidavit. Same affidavit.
Your worship.
Look at the initiating officer's comment. Farooqi is an average officer.
Yes, your worship.
And the rest of it, as you read out from page 35. At the bottom left, your signature is there, date is there, 1st April.
But what is there, my lord? What is important?
Where is your statement on facts?
My lord, firstly, if your worship sees,
We will not hear a word unless it's in your affidavit. Where is it in your affidavit? You got a chance to deal with this. We gave you a chance to file a rejoinder. In your rejoinder, that should have come. Read us from your rejoinder, how have you dealt with, in what circumstances? They put a gun on my head on 14th January 2020. I had to backdate the date, antedate it.
My Lord, I have said so. The contents of para 4 of affidavit
That's all right.
in opposition
Thank you.
are incorrect, incorrect, twisted and distorted, and denied as stated. Your Worship, kindly, my Lord.
Thank you. The appeal is based on
My Lord, one
utter
thing,
falsehood.
my Lord, one thing, my Lord.
They're Delhi, not here. Utter falsehood. Paragraph. The appellant, comma,
Your Worship, kindly,
an assistant commandant in the Assam Rifles,
my Lord, you are second in command, my Lord.
a second in command in the Assam Rifles, founds his challenge to not being promoted on the ground that the relevant departmental promotion committee found him unfit merely on the ground that one of his relevant annual confidential reports graded him as average, comma, but such ACR was not made available to the appellant, nor was the appellant afforded any opportunity to make a representation against the same. Full stop. Paragraph.
Your Worship, I am sorry for intervening, my Lord. This kindly, my Lord, kindly have page 25 of this paper book only, my Lord. It says that no verbal warning, no written warning has been given to me.
That's all right.
Your Worship, it says nil.
Thank you.
Then kindly have page 29, Your Worship.
Thank you.
My
Please
Lord,
take your seat.
kindly, please, my Lord.
Thank you. The
My Lord,
writ court proceeded on the basis
permit me, my Lord, 3-4 minutes, Your Worship. Kindly, please, my Lord.
that
In the interest of justice, please permit me for 5 minutes, my Lord. Permit me for 5 minutes. Kindly,
you will pay for it. Tell us for 5 minutes.
Your Worship, kindly 5 minutes, my Lord.
Yes, carry on.
My Lord, what is required, what I have read the policy is that entire CR will be communicated to the petitioner. This was incomplete ACR at that stage on 1st April because it was initiated only by one officer. The other officers reporting chain of command, that report has not been that has not come to me. That we are not aware about it, my Lord. And he says that no verbal warning, no written warning has been given to me. It sustains my submission before your Lordship that no warning was given to me, whatever it is. Then secondly, at page 29, the DIGR says that warning letter was issued to me. If your Lordship reads this, in conjunction with this, the suppression of material fact and fraud is apparent, my Lord. Abuse of power is apparent, your Lordship. Page 29, page this, Faruqi is a twice of 36 Assam rival. Performed, above काट दिया बाद पहले लिखा हुआ था, my Lord. Average, he was verbally counseled by me. He had not given one in April 2015 and by the Commandant 36 Assam Rifle on 8 April 15.
Where are you reading from?
My Lord, page 29
Of
the same paper book, my Lord.
the same affidavit or the petition?
This is, my Lord, which has been shown to your Worship, Annexure A.
Page 29.
Your Worship.
Faruqi was a matured officer.
No, my Lord. Faruqi was twice of 36 Assam Rifle, first 18 paragraph, my Lord. Top one.
This is the signature of whom?
Here, there is no signature of mine, my Lord.
No, not your signature. Who is this is the reviewing officer.
This is DIG Assam Rifle.
This is the reviewing officer. And let us see the reviewing officers.
He says Faruqi as twice of 36 Assam Rifle.
Just a second. Where was the previous one?
Sir, reviewing officer is para 17, my lord.
Just a second.
At page 28.
Where was that previous? There was a full thing.
2020.
Yeah. I think that is at page 38.
The counter affidavit
Just a
was
second, just a second.
Is that page 35? 35.
The thing remarks of DI GR, 24th April 2016. This is the reviewing officer.
Sir, reviewing officer is page 17, my lord.
Reviewing officer, just
Page 28, my lord.
28 is DI GR.
He also says verbal warning
just a
written,
second.
nothing has been given to me.
Faruqi, second in command of 39.
Sir, I have been upsetting number of times as a commandant.
Yes, what is wrong?
No, wrong is, my lord, page 29.
29, yes.
Page 29, 18, DIG air comment, my lord.
Yes.
It says Faruqi has twice of 38 Assam rifle performed. Firstly, he wrote above average, then he cut it. Then he was verbally counseled by me in April 2015 and by the commandant 36 Assam rifle on 8 April 15 to improve his interpersonal conducts with officers and JCOs OR. Being a permanent LMC, his contribution to city operation was limited. Now this is what he says for the particular period, my lord. I have said, and the initiating officer says, which your lordship has just said, verbal warning, written warning, nil. Now
We are not on the merits of that.
No, sir.
We are not on the merits of that.
I am not on the merit. I am on law point. The law is that you cannot write anything adverse without informing the person concerned. I have stated in para 2015 of my writ petition, your worship. Para 15 of writ petition, your worship, that is page 59 of the paper book, my lord.
Just a second.
My lord, so much lies have been placed before your lordship, so much frauds have been played. I will just display before your lordship, apparent on the face of the record.
See, brother,
Para 59.
his signature over here. His signature over here is obtained on 1st of April 2006, whereas these comments are 13th of May and 24th of April. And also see the note below saying that in case 18 contains any advisory remark, has to be given to deity. In case 19A contains any advisory, Mr. Devnath, come to page 29 of your affidavit here. Says Faruqi performed average.
Yes, sir.
And it also talks about counseling and letter being written. April 2015 and 8th April 2015.
Yes.
Now you come to the bottom of that 18. In case subparagraph 18A contains any weakness or advisory remarks, subparagraph 18A and B, excluding box grading, will be communicated to the ratee. Where is this communication? Where is this communication?
As per record, you will see there is no others.
There is no other communication.
My Lord, I have also stated in paragraph 15 of my writ petition that the further with regard to the warning letter dated so and so, it is the case of the petitioner that the petitioner never received the aforesaid letter from the Commandant 36 Assam Rifles as claimed by the DIGR. Now it was the responsibility of him to have produced the communicated that warning letter before your Lordship to show that yes, he has been communicated warning letter. Now, my Lord, army order has been placed. The respondents has framed the army orders, policies and guidelines on rendition of CRs. And it provides, my Lord,
in your affidavit, in your rejoinder, why don't you deal with this? Why don't you say that my signature on that day does not mean anything because of ABCDE? You have an affidavit of 40 pages in which you give lecture and you refer to Supreme Court judgments, but you don't deal with facts. Affidavits are not meant for lecture on law. Affidavits are meant to record facts.
Your Worship, it was stated earlier, my Lord. Just a second, Your Worship, I will. My Lord, one more point, if Your Lordship permits, my Lord. If Your Worship sees...
Just a second. Where is your writ petition in the paper book? Where is your writ petition?
My Lord, since it was not communicated, no representation was made, my Lord.
Where is your writ petition?
Writ petition, Your Worship. It is, my Lord, Annexure 1, page, commencing page, my Lord. It is, I have read Annexure 1, my Lord, commencing page 49. Your Worship,
Just a second.
I was drawing Your Lordship attention to page 59, internal page 11. Para 15, Your Worship.
You filed an affidavit in the writ court?
Yes, Your Lordship.
Where is your affidavit over here?
My Lord, this is Annexure
16.
Annexure 16, Your Worship.
Just a second. Paragraph 19.
It is, my Lord.
Just a second. Come to page 230. Page 230.
230, this paragraph 19 is.
Paragraph 19. About 10 lines from the bottom. the petitioner has stated that ACR just above that, has communicated to the retty about his adverse remarks along with warning letter. Where is annexure O? Where is annexure O to this?
Please. My lord, page 292, my lord. Sorry.
What is this? No. This is annexure O. How do you get this annexure O?
Annexure 293 page, my lord.
What connection does this have?
It is 1st December 2017 letter, my lord.
Mr. Devnath, come to page 59 of that brief. Come to the last 5 lines, last 6 lines. Stand taken by the reviewing officer is contradictory. And then, further with regard to the warning letter of 8th of April, it is the case of the petitioner that the petitioner never received the aforesaid letter from the commandant as claimed by DIGAR. Purported warning letter was issued So once he says he never received it, where have you shown that he received it? He has made a positive statement, I have not received it.
So is the record it is not there.
That's all.
You receive, if my lord.
Finishing? Correct.
One point.
First blush,
One more point I want to inform you.
it would appear you'll get all the relief.
Just a second, sir. The petitioner has been now promoted to the rank of commandant with effect from 1st February 2023.
Just a second. 1st February 23.
And he has assumed the command of commandant on 1st February 2023. Now the relief of before your lordship, what I have prayed in my appeal was that limited to that his supersession, his seniority with effect from the date his juniors have been promoted.
Seniority, pay, everything will be as if he was promoted by the DPC.
Yes, your lordship.
Yes. The at first blush, particularly on the basis of the papers relied upon by the Assam Rifles, it would appear that the writ petitioner approached this court with an utterly false case. Full stop. Indeed, the present appeal was itself being dismissed, before it was pointed out on behalf of the appellant that the papers relied upon by Assam Rifles do not match up, and it is apparent that such papers have been doctored to the prejudice of the appellant. Full stop. The appellant complains that a DPC held on October 14, 2019 unfairly found the appellant to be unfit to be promoted. Full stop. The reason given by the DPC was that in one of the annual confidential reports relevant for consideration, that for the year 2015-2016, the appellant herein was rated as average, full stop. The DPC was of the opinion that in terms of the prevailing rules, when an officer had been graded average during any one of the relevant years for which the ACRs had to be considered, such officer would not be entitled to promotion. Full stop. Paragraph. The case that the petitioner, that the writ petitioner appellant, that the appellant as the writ petitioner brought to this court was that prior to January 13, 2020, he had no inkling of any adverse remark that had been attributed to him in any of his ACRs. Full stop. There is also a document, there is also an undisputed document revealing that by a written communication of November 29, 2019, the appellant was forwarded copies of several of his ACRs and that he received the same on January 13, 2020. Full stop. Paragraph. Based on the fact that there may have been an adverse remark made in the ACR of the appellant that the appellant had not been informed of, the appellant questioned the propriety of the decision not to promote him from second in command as revealed by the DPC report, DPC minutes of October 14, 2019. Full stop. Paragraph. In course of the proceedings before the court of the first instance and even before this court, Assam Rifles relied on a document that reveals that the grading of average had been completed in respect of the year 2015-2016 by April 1, 2016, and that the appellant herein was shown a copy thereof, was shown the same ACR, whereupon he appended his signature on April 1, 2016. Full stop. Ordinarily, it would not occur to a court of law that a disciplined police force as the Assam Rifles would attempt to play fast and loose with court and give a false impression with an attempt to deceive the court. Full stop. But that is exactly how the Assam Rifles has conducted itself in the present proceedings. Full stop. Paragraph. The relevant rules of the organization, which are not in dispute, require that ACRs be made available to the concerned personnel contemporaneously. Full stop. This follows repeated judgments of constitutional courts in this country requiring adverse reports to be brought to the knowledge of the concerned personnel so that they may have a chance to represent their against. Full stop. Oftentimes, the career of a brilliant or a good officer may be ruined because of the adverse remark of a superior who may have a personal grudge against the officer and whose adverse remark may be reviewed and corrected by the superior's peers. Full stop. Paragraph. The writ court found that since the appellant herein had acknowledged having seen the ACR by signing on the first page thereof and appending the date of April 1, 2016, it did not lie in the appellant's mouth to suggest that he was not contemporaneously aware of the average rating in his ACR for 2015-16 and his consequential ineligibility to be considered for promotion at the DPC conducted at the DPC of 2019. Full stop. Paragraph. Despite the appellant being afforded a chance to use a rejoinder in the appeal and to specifically deal with the allegations in the affidavit filed by Assam Rifles in the appeal, comma, the appellant's rejoinder includes lectures on legal theories, reports of case laws, and diverse other facts, including maybe the weather at the South Pole, semicolon, but not the essential facts required in an affidavit. Full stop. It has become a fashion of the mediocre these days to hold forth on legal issues, principles, and precedents without referring to the basic facts in dispute. Full stop. It must be remembered that pleadings filed before court are primarily to enlighten the court on the factual position and, comma, the effect of the facts based on the law may be indicated in short. Full stop. Paragraph. In the present case, comma, the entire ACR for the year 2015-2016, entire ACR of the appellant for the year 2015-2016 was disclosed in the affidavit filed by Assam Rifles, and on the first page the petitioner's signature appeared clearly. Full stop. It was thus incumbent, not petitioner, appellants, it was thus incumbent on the appellant to indicate why the facts were such that the appellant's signature on the first page of the ACR should not be accepted as conclusive evidence of the appellant having been given the ACR or shown the same contemporaneously. Full stop. Paragraph. However, comma, not however, thankfully, comma, paragraph 15 of the writ petition contains the primary attack and what ought to have been indicated in greater detail in the rejoinder in the appeal finds mention in such paragraph 15 of the writ petition. Colon, set out paragraph 15 from the writ petition from page 59. Full stop. Paragraph. In the set of documents pertaining to the ACR of the appellant for the year 2015-16, comma, the first page carries the signature of both the initiating officer and of the appellant herein with the same date of April 1, 2016. Full stop. apart from the initiating officer's comments which are indicated at paragraph 16 of the ACR, there are other parts to the ACR including paragraph 18, full stop. Paragraph 18 has been chosen out for special mention since such paragraph is damning to the appellant herein, and if the contents thereof are true and the appellant was aware of the same contemporaneously, the appellant would have no case at all. Full stop. Paragraph. Paragraph 18 of the relevant ACR contains the comments of the Deputy Inspector General of Assam Rifles. Full stop. These comments have been made on April 24, 2016. Full stop. The DIGAR remarks as follows, next line. Farooqui, Farooqui as 2IC in figures, 2IC of 38 AR performed within quotation marks average small a, full stop. He was verbally counseled by me in April, APR 15, to improve his interpersonal conduct with OFFRS and JCO small s stroke OR, full stop. Being a PERMT small LMC, his contribution to CT capital O small ps was limited, LTD small, full stop. Then next paragraph, copy of warning letters issued by COMDT 36AR to the OFFR small VDA 36AR letter number 59503 stroke RD stroke capital P small ERS stroke 2015 stroke 143 dated 08 APR April 15 is enclosed ENCL full stop close quote. Paragraph. It may be necessary to look at the applicable rules at this stage. Full stop. As per an office memorandum issued by the Ministry of Personnel, issued by the Department of Personnel and Training, dated May 14, 2009, the full annual performance appraisal report, bracket otherwise known as annual confidential report or ACR, bracket closed, including the overall grade and assessment of integrity, open quote, shall be communicated to the concerned officer after the R capital report is complete, with the remarks of the R capital reviewing O capital officer and the accounting authority AA capital ... Full stop. The same memorandum also mandates that the concerned officer, open quote, shall be given the opportunity to make any representation against the entries and the final grading given in the report within a period of 15 days from the date of receipt of the entries in the APAR. Full stop, close quote. Paragraph. It cannot be missed that as late as in the year 2017, the Ministry of Home Affairs noticed that the transparency as required to be maintained in respect of APARs may not have been followed by the several departments of organizations under such ministry. Full stop. In a memorandum of October 16, 2017, the ministry advised all central armed police forces to, the open quote, ensure that the APARs of the officers stroke officials are communicated to them
Consolidated acknowledgement information.
Communicated to them close quote, with appropriate acknowledgement in such regards. Paragraph. The two aspects that need to be highlighted in the present case is that the office memorandum issued by the DOPT in the year 2009 required the completed APAR or ACR to be communicated to the relevant employee, and that such employee had to be afforded a chance to make a representation against any adverse remark that may be contained therein. Full stop. Paragraph. Against such backdrop, it is the ACR of 2015, it is the appellant's ACR of 2015-16 that has been relied upon by Assam Rifles that needs to be seen in greater detail. Full stop. It is true that the appellant had signed the first page of the ACR bearing the date April 1, 2016, but it is apparent on a reading of the entirety of the ACR that as on April 1, 2016, the ACR had not been completed. In fact, even the though the initiating officer's comments appear to have been made on April 1, 2016, the reviewing officer's comments appear to have been made on April 9, 2016, the DIG's comments on April 24, 2016, and the Inspector General's comments on May 13, 2016. Paragraph. Though the appellant seeks to indicate the internal inconsistencies in the comments of the four superior personnel and also seeks to rely on the praise heaped on the appellant and his performance in the other ACRs, there is no need to go down such lane once it is apparent that the subsequent superior officer, despite his comment apparently to the contrary, has indicated the initiating officer's comments as justified. Full stop. Paragraph. What is undeniable is that there is nothing on record to demonstrate that the appellant was forwarded a copy of his ACR for the year 2015-16 upon the completion thereof, full stop, merely because the appellant signed the first page of the document on April 1, 2016, by which time the initiating officer may have already indicated his comments, would count for nothing, since the initiating officer's comments were subject to review, modification or correction by the superior officials. Full stop. No attempt has been made by Assam Rifles to show that prior to the subsequent to the completion of the appellant's ACR for 2015-16 and prior to the DPC meeting of October 14, 2019, The appellant herein was made aware of his complete ACR for the relevant year. Indeed, the only other relevant document that is on record demonstrates that a bunch of ACRs, including for the year 2015-16, was made over to the appellant only on January 13, 2020, though the letter in such regard was dated November 29, 2019. Full stop. Paragraph. It is elementary that when rules are in place, matters which are governed by the rules have to be dealt with in accordance therewith. Full stop. The appellant herein was seriously prejudiced in the appellant not being provided the full complement of his ACR for the year 2015-16 and the adverse rating therein for him to make a representation against the same. Full stop. Since it is evident from the documents produced that the appellant did not have his completed ACR for the relevant year prior to the DPC meeting of October 14, 2019, the DPC could not have taken the adverse rating of the petitioner, of the appellant, in the year 2015-16 into account. Full stop. Paragraph. As a consequence, the appellant would be entitled to promotion at the DPC of October 14, 2019, since the purported adverse remark against the appellant in the appellant's ACR of 2015-16 would have to be disregarded upon the employer's failure to afford the appellant a chance to represent against the same. Full stop. Paragraph. It is submitted on behalf of the appellant that with effect from February 1, 2023, the appellant has been promoted as commandant. Full stop. Thus, the relief that the appellant is now entitled to will be that the appellant will be deemed to have been promoted to the relevant promoted post as the appellant's peers at the DPC held on October 14, 2019, and the appellant's consequential seniority and pecuniary benefits will be assessed accordingly. Full stop. The additional pecuniary benefits that the appellant is now found to be entitled to should be made over to the appellant within 3 months from date. Paragraph. The judgment and order impugned dated so and so is set aside in as much as it failed to appreciate that in terms of the relevant rules as indicated in the office memorandum of the DOPT of the year 2009, all employees were entitled to their completed ACRs and, in particular, if there was any adverse report against an employee, comma, such employee had to be afforded a chance to represent against the same within 15 days of the completion of the report. Full stop. Clearly, comma, Assam Rifles acted in breach of the obligation that it owed to the appellant and in acting as aforesaid, comma, affected the appellant's right to promotion. Full stop. Paragraph. Apart from the fact that the appellant was harshly dealt with by a disciplined police force, comma, it is evident that the Assam Rifles had tried to hoodwink this court into believing that the appellant had due notice and knowledge of his ACR of 2015-16 long prior to the DPC finding the appellant unfit for promotion. Full stop. The Director General of Assam Rifles would do well to advise his officers that they should be extremely careful in presenting their side of the case or in preparing affidavits before a court of law. Full stop. Paragraph. In addition to the benefits that the appellant will be entitled to receive, comma, the appellant will be paid costs assessed at rupees 1 lakh for the troubles that the appellant has had to go through to vindicate his right. Full stop. Such payment will also be made within 3 months from date. Yes.
Memorandum is accepting authority. And transcript of the copy.
Accepting authority. Just remember it if I don't forget to do it just Yes. Call on the next matter, please.
Obliged, my lord.
Next time we'll pull up, Mr. Devnath, next time we'll pull up the deponent of the affidavit. It's much easier to say I've made a mistake. You're an authority. Your individual officers may be prejudiced. But you cannot come and play the fool before a court. Yes.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
This
I am appealing for.
This is a new matter.
New matters. My lord.
Yes.
My Lord, I am appearing for the appellants in serial number 123, my Lord.
Yes. Appeal
For
against
the,
An order of sestet. my lord.
Sestat.
indeed, my Lord.
This is the
Appeal
second
is
round.
maintainable
Appeal is maintainable, my lord.
within time.
My lord.
Indeed.
Want to finish it off here and now?
I couldn't go through, my lord. It was quite voluminous, my lord. I'm praying for some time, my lord.
The appeal has been filed within time and is required to be heard. Paragraph, since the department seeks some time, comma, let the appeal appear a fortnight hence, full stop. Same order in the other two matters. Fortnight.
My Lord, if I may request for a specific date, my Lord, subject to my Lord's convenience.
That depends on if you have the patience to see the order at the end of the day. Yes, call on the next matter, please.
Item number
Oblige
4.
me.
How many days?
Your Lordship, this is 88 days, Your Lordship.
How many?
88 days, Lordship.
Very. Convicted under?
Convicted under Section 6 of POCSO
POCSO.
and then 506 IPC Lordship, for 15 years.
In view of the good ground shown, the delay of about 88 days in preferring the appeal is condoned. Paragraph, the appeal is taken on board. Paragraph, let the lower court records be called for immediately. Full stop. Paper books should be prepared within 8 weeks from date, in adequate number, and copies thereof circulated. Full stop. The appeal will come up for hearing 10 weeks hence.
DPO Branch, First Branch, Lordship.
From the main list, item number 1.
Lordship, this is an appeal under section 37 of the
Yes.
Act. There is only one claim, Your Lordship, that relates to the
Yes.
additional cost and expenses which the contractor has incurred because of the delay. Here the contract period was from 31/8/2009 to 3/08/2012. Before this period expired, contractor sought extension of time on 2 occasions. We have granted him first extension on 28/7/2012 up to 31/8/2013, and second extension was granted from 1/9/2013 to 31/7/2014. Now, for this contract period, even the contract period was not expired, he raised a claim for the period commencing from 31/8/2009 to 30/6/2011. that is within the contract period. Contract period was not over. Within the contract period, he has raised a claim, though we have granted him extension up to 31/8/2013, first extension, but he lost the claim for the period up to 30th/6/2011.
And the claim was for additional costs.
Additional cost which he incurred. Now, according to the contractor, he said his case is this, that for this period, he estimated that he will be completing the work of 144 crores. But because of certain contractual lapses on my part, he could not achieve that target, and the target achieved was much less than the estimated target. And that is his case, and he claimed compensation for that period. Now, this delay, according to the contractor, was caused for 4 reasons. The first reason was delay in handing over the work front. Second reason was failure to provide access to site. Third was delay in construction drawing. And fourth one is the extra work. These were the 4 contractual lapses, and for these contractual lapses, he has claimed extension of time first. He is granted extension of time, and he accepted the delayed performance of contract without reserving any right to claim compensation for this extended period of contract. No notice, we were not placed on notice that he will also be claiming the compensation for this extended period. Now,
First, section 73,
73, Your Lordship.
Contract Act.
Your Lordship makes a provision that in case of contractual defaults, contractor has a right to claim compensation. Compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach which the party knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. Compensation for failure to discharge obligation resembling those created by contract. When an obligation resembling those created by contract has been incurred and has not been discharged, any person injured by the failure to discharge, it is entitled to receive the same compensation from the party in default as if such person has contracted to discharge his and has broken his contract. In estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. Your Lordship, I may also place section 55 because learned arbitrator has relied section 55 and 73 in awarding the compensation. Effect of failure to perform at a fixed date in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time or certain thing at or before specified times and fails to do any such things at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee, if the intention of the party was that time should be the agents of the contract. Effect of such failure when time is not essential. If it was not the intention of the parties that time should be of the agents of contract, the contract does not become voidable by a failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promiser for any loss occasioned to him by such failure. Case is covered, Your Lordship, under the third part of section 55. Effect of acceptance of performance at time other than that agreed upon. If in a case of contract voidable on account of the promiser failure to perform his promise at the time agreed, the promisee accept performance of such promise at any time other than that agreed, the promisee cannot claim compensation for any loss occasioned by the non-performance of the promisee at the time agreed, unless at the time of such acceptance he gives notice to the promiser of his intention to do so. Your Lordship, in the instant case,
has it been found that time was of essence?
no, there is no finding, but as per the contract,
Has it been found that time was of essence?
no, there is no finding on that.
If there is no finding, time is of essence, terdim does not apply.
No, Your Lordship, as per contract provision, clause 24 of the condition of contract, it is not only the initial time, but even the extended time is the agents of contract. That is not disputed, and it is provided in the contract.
Let us see. Clause 24, where is clause 24?
24, Your Lordship.
Merely because you stipulated time does not mean time is of essence.
Yes, my Lordship, that is true. That is true.
Let us see clause 24.
Yes, sir. Page 137, Lordship. No, 137, Your Lordship. Just
137?
no, not Your Lordship. 200. I'll just take it out, sir.
Page 196.
Yes, Lordship. Page 198.
198.
198. Your Lordship, subclause 1, Roman 1, time allowed for the execution of the work as specified in the contract or the extended time, if any, in accordance with those conditions, shall be the agents.
Yes, but it's undermined by 3. However, if the work is delayed on account of.
Yes.
So
then
therefore,
it provides that extension of time.
So therefore, time
Then,
is
Your
not of
Lordship,
essence of the
I just draw the attention of my Lord to clause 7. Clause 7, which is a no claim clause, Roman 7. No compensation is admissible other than whatever provided for in the clause number 20, suspension of work for any extension of time if granted. We have granted him time extensions, and our contract with him is that other than he is entitled only for the extension of time and the compensation which is provided under clause 20. No case is made out under clause 20 which deals with suspension of work.
Yes.
Lordship, I will also draw the attention of my Lord to page 138. 138. Before giving the bid, contractor has asked certain clarifications, and those clarifications were provided to him by Annexure 4, 135, page number 135. This is before the bid. Then I take to your Lordship page 138, column serial number 10. He wanted an amendment of this clause, 24(7), page 138. Clause 24(7). No compensation is admissible other than whatever provided for in clause number 20, suspension of work for any extension of time if granted. That is what is the tender over stipulation. What he wants, request the employer to incorporate the provisions for reimbursement of indirect losses likely to be suffered by contractor on account of delay not attributable to contractor in addition to extension of time. Stipulation in detail bid document shall prevail. Now, before giving the bid also, his specific query to the corporation was this, that amend this clause so as to include the compensations, and knowing well he has bid and LOI was issued and the work order and the contract agreement was signed, Your Lordship, signed. Now, in this case, Your Lordship, I am raising 3 points. My first point is this, that there exists stipulation in the contract agreement which debars the claimant to, which debars the contractor to claim compensation on account of delay for which extension of time is granted. Now, for that, Your Lordship, I have referred to clause 24(7). Then Your Lordship has also seen clause 20. Then Your Lordship, I take to page 261, escalation clause, page 261. Page 261, it starts from 258, page 258, clause 74, price adjustment variations. For the delay which is occurred, we provide the escalations as per the formula given in clause 74. Then clause E at page 61 in the bottom, Your Lordship will find that it is provided no claim whatsoever for price adjustment variations other than those stipulated above shall be entertained. This is another clause which is provided. Then, Your Lordship, I take to clause 54, page 238. No, clause 55, Your Lordship may see. I read it. Time for payment and interest. No claim for interest or damage will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer in charge on the one hand and the contractor on the other hand. Or, this Your Lordship word or is very important. I'll take to one judgment, Your Lordship. With respect to any delay on the part of engineer in charge, making periodical or final payment or in any other respect whatsoever, then Your Lordship, here this one, with respect to any delay on the part, this is a wider term which includes each and everything for which the delay may be caused. Then, Your Lordship, I take page 250. Clause 70, it is a part of clause 70. 70 clause is at page 247. I am reading Roman 9. The arbitrator appointed shall have no power to award interest on any claim referred to the arbitration. No claim for interest or damage on whatever count will be entertained by the corporation with respect to any dispute, difference or misunderstanding between the corporation and the contractor. Even by this clause, arbitrators were not empowered to award interest, and the interest has been awarded despite these two specific provisions. Then, Your Lordship, I also take to clause 9 at page 178. Lordship, I may have little water. Page 178. One of the reason for delay was the delay in handing over the site, and that is provided in clause 9. The site will be handed over to the contractor in parts progressive, and the contractor will be permitted to use the site and lands under the control of the corporations and required for execution of work in accordance with the approved construction program, subject to such condition as detailed below. The contractor shall not commence any operation on such land except with the prior approval of the engineer in charge. Then next line is, Your Lordship, is important for me. However, in case delay in handing over of the site to the contractor, the corporation shall only consider suitable extension of time for the execution of the work. It shall be clearly understood that the corporation will not consider any other compensation whatsoever towards idleness of contractors, labor, equipment, etc. Your Lordship. This is another, Your Lordship, no claim or no damage clause which is provided in clause 9. Then Your Lordship may also look to clause 50. There is a award against me about the DG diesel generator, which is awarded around 50 lakhs against me, which is contrary to the specific provisions. Clause 50. The contractor shall make his own arrangement for supply of power to meet the requirement for execution of the work at his own cost. The contractor shall install, operate and maintain electrical distribution system for power distribution throughout his working site and temporary facility. In case the corporation is in a position to make those facilities available, the power shall be supplied at 11 kV so and so. Convenient points to be decided by the engineer in charge. The rate of per unit of such electricity consumption shall be applicable as fixed by the corporation. Next line is important, Your Lordship. Non-availability of the power shall not entitle the contractor to make any claim whatsoever for time extension or extra payment. The power supply shall be disconnected on completion of the work and vacation of the site as early as possible, Your Lordship. Now, his case, so far this claim is concerned, his case was this, that electricity could not be supplied regularly, so they were using generator, and for which they incurred the extra expenses. Then, one more point, Your Lordship, I wanted to stress upon this Honorable Court is this, that issue cropped up before the Judge Commercial Court as to whether the contractor has issued any notice and put the corporation on notice for damages, notice to claim damages. Now, after the close of the argument, the contractor filed an application before the Judge Commercial Court enclosing a document, enclosing a letter which was not part of the record of the arbitral tribunal. We have raised the objection.
Yes.
That before the Judge Commercial Court, an application was filed to take certain letter on record which was not forming the part of the arbitral tribunal. We raised our objection, but despite our objection being raised, the Commercial Court, though it did not have the power, but took that letter on record and held that this is a notice which was issued by the contractor for claiming compensation. As a matter of fact, that letter was not a notice but a claim which was raised, and same claim was rejected, Your Lordship. Now, there is few judgments, Your Lordship, compilation.
Later. First and foremost, show us where is the request for extension pursuant to which you granted the first extension. Where is the request for extension following which you granted extension from 28th July?
Your Lordship, Annexure 22, page 556.
Page 556
is the extension granted.
No. Where is the request for extension?
Lordship, possibly that letter is not on the paper book. If your Lordship, but the extension which we have granted.
No. We have to see the request for extension.
No, that letter contains the request also.
So how do they request you for extension?
They have requested, Your Lordship, I have to just locate the tribunal record. They have.
To that letter. Where is that letter? Page? Your extension page?
Page 556.
556.
He is dated 28/7/2012.
Where is his letter of
your application?
September 2011.
15 September 2011. Your Lordship, this one is not in this paper book. I will be in a position to produce it, but right now it is not in the paper book. Your Lord. But this request is there. It is mentioned your application number so and so, dated so and so. With reference to above, the undersigned would like to inform you that the corporation is pleased to grant provisional extension of time in respect of the aforesaid contract up to 31st August 2013 without liquidated damages and without prejudice to the right of the corporation to impose any liquidated damages, compensation for delay, etc., while granting final time extension. The other is the page, next page is typed copy. Then 559 is the second extension, and typed copy is at page 560. Here also your letter number dated, number so and so, dated 24/11/2012. With reference to above, the undersigned would like to inform you the corporation is pleased to grant extension of time provisionally in respect of the aforesaid contract with effect from 19/2/30 without liquidated damages and without prejudice to the right of the corporation to impose any penalty. Your Lordship, the claim which the contractor has lost does not fall within the extended period. It falls within the...
Let us see how the arbitrator has dealt with it.
Yes. Your Lordship, since there is only one claim, I'll just, page 64. Lordship. Page 64. Claim number 1, claim for reimbursement of additional court expenses incurred due to delay and disruption attributable to the respondent from commencement of the work till 30th/6/2011. Amount is 40 crore 69 lakhs 05142. Admissibility of the claim. The works were to be taken up from the issue of letter of intent, that is 31/8/2000, to achieve the target. A construction program was submitted on so and so date, which was approved by the respondent However, during the execution of work, the respondent repeatedly defaulted on his contractual obligation to provide encumbrance-free site, access to site, construction drawing. Beside that, additional work also instructed to be executed. So, delay, so for the admissibility of the claim, it is based upon these 4 elements, Your Lordship. Then he discussed the facts are narrated. Then come to page 67, Roman 3. All the above regions were beyond the control of the claimant and entitled the claimant for extension for time, as well as consequential cost. The respondent has granted EOT for delays caused due to events up to 30th/6/2011. This is possible, is not correct. We have granted extension up to 31/8/2013. On 28/7/2012, and so the issue of EOT does not form part of the terms of reference of the arbitrations. The parties have jointly verified the disruption caused to the work. As a consequence of the delay not attributable to the claimant could not work in the planned manner and planned turnover. As per agreed construction schedule, the turnover should have been 144.67 crores approximately till 30th/6/2011. 11 up to 31/8 have been considered in the EOT granted up to 31/8/2013, but could achieve only 46.27 lakh turnover due to the hindrance. In effect, the claimant's resources remained underutilized to an extent of 68% during the period up to 30th/6/2011. Then, Your Lordship, I come to Roman 6. In view of above, the claimant submitted its claim for cost for the period from 31/8/2009 to 30th/6/2011 to the engineer on so-and-so date. The quantification of the claim, what is the case of the contractor, it has been spelled out. And claim number 2 and 3 are rejected, so I am not taking to Your Lordship on. I am taking what was my case before the arbitrator as at page 73, paragraph 5.1. As regards admissibility of the claim, my case is this: the respondent had handed over all the work front in time, but the progress by the claimant was slow due to inadequate mobilization of machinery, manpower, and other resources. All the work front were encumbrance-free and accessible. All the required drawings were issued in the phased manner. All the additional work instructed to be executed were related to the main work. The engineer in charge, EIC, has the power to make such deviation under the contract. The wide gap between schedule and actual execution has been due to the lack of planning and under mobilization on each work front. Work-wise details are recorded in the following paras. Now, different fronts were there, but in all, my case has been, however, the claimant has been compensated for the time lost as per contract provisions. That is, we have granted him time extension and we have paid him escalations. This is with regard to each and every front. We have mentioned that he has been compensated. Then, as regards the quantification of the claim, Your Lordship, at page 78, my case is the claimant has already been fully compensated in the form of paid price adjustment in the extended period of the contract. The claim is not justified at all. It is to be established as to which party has violated the contract provision. The respondent has fulfilled all contractual obligations. Without prejudice to the basic stand of the respondent about the non-admissibility of the claim, then we are giving the explanations, Your Lordship. Then, finding of the tribunal, Your Lordship, is at page 84. Paragraph 7.1. there is no dispute between the party with regard to the loss of days in working production during execution of work, which have been clearly identified as attributable to the claimant or the respondent. The exercise has been carried out on all the work fronts. Your Lordship, this exercise was carried for the purpose of grant of the EOT. So far this part is concerned, there is no dispute. The claimant had worked out the factor of underutilization of its resources based on delay not attributable to the HCC after giving credit for the days lost on their account. This was objected to by the respondent since loss of productivity might involve so many other factors in execution stage. The respondent considered the underutilization only due to factor attributable directly to the respondent. The same has been agreed to by the claimant. Then 3, it cannot be disputed that due to underutilization of resources, the actual production had been much less than originally planned while bidding for the work, and so resulted in financial losses to the claimant. The losses have been claimed under various subheads as dealt with below. Then he is dealing with maintenance charges and what. Then, Your Lordship, I come to, so far my stand, basic stand is this, that he has been compensated. What the tribunal, what the arbitrator has to say, Your Lordship, Roman 4 is important. The argument of the respondent that for delays caused on account of the respondent, the claimant has been fully compensated as per the contract provision, that is by way of EOT and price adjustment, is not correct. Price adjustment certainly does not cover any losses due to delay hindrance caused on account of the employer respondent. It is here, Your Lordship, according to my humble submission, that the arbitrator went wrong in holding that does not cover any losses due to delay. He has not referred to, dealt with the clauses which are relevant for this purpose. And without taking into consideration, he has awarded this claim. The Indian Contract Act is also clear in this respect, particularly Section 55 and 73 of the ICA 1872. Once there is a breach of contract by the respondent, the claimant is entitled to be compensated for the losses, damage suffered by the claimant. This position of law is clearly set out in the case of so-and-so, so-and-so. Here in this both, there are two cases which he has referred. In both these cases, the notice under Section 55 was served. In view of the foregoing detail, number 6, in view of the foregoing details, the AT is of the considered opinion that in this particular case where the breaches resulted in a reduced progress to almost 32% of the scheduled target, the claimant is genuinely and legitimately entitled to be compensated for the losses, damages sustained due to underutilization of plant and machinery and labor, etc. Then, Your Lordship, I just come to the table, page 88, where he has awarded the compensations. First, A, ownership cost of equipment, cost of labor, site overhead, officers and staff, revenue and other head office, and higher charges for DG set he has awarded 4196,416, which is contrary to the contract clause which I have pointed out, Your Lordship. Now, I have, Your Lordship, 3 points in this matter. My first point is this, that the arbitrator has awarded interest also. Your Lordship will come to page 92, 10.0. interest shall be payable on the amount awarded under claim number 1 at the rate of 13.25% per annum from the date of reference to the arbitral tribunal, that is 19/2/2014, up to the date of award, that is 15/9/2015. Future interest shall be payable from the date of award up to the date of actual payment at the rate of 15% per annum. However, no such interest shall be payable in case payment is made within this period. Now, first point, Your Lordship, I take it from this interest portion, Your Lordship. I have given two contractual provisions. That is the clause number 55 and clause number 70 within bracket Roman 9, which debars the arbitrator even to award interest, and secondly, it also prohibits any award of interest under clause 55. While awarding interest, the learned arbitrator has failed to look into these contractual clauses and has awarded the interest. Your Lordship, I'll just have 3, 4, 5 judgments.
Mr. Choudhury,
may I pass it on?
Wait. There appears to be a problem. There appears to be sufficient bar indicated in the contract. Even if there is no bar in the contract, how does he arrive at these figures?
The figures are admitted, not figures, my lord. The incident of delay is admitted.
That is neither here nor there. But the contract provides you will not be entitled to claim any compensation on account of that.
There, my lord, I have a submission. Issue not raised in the statement of defense, issue not raised in the arbitration. Before the commercial court, my lord, it's recorded in the judgment of the commercial court that this issue was never raised earlier. So it's a complete waiver. They can't take this issue now.
Which issue?
My lord, the issue of no damage clause. No interest also not raised.
Is the issue as to the jurisdiction of the arbitrator? It goes to the very root.
Section 4 waiver, my lord.
Goes to the very root of the arbitrator's authority.
No, it's section 4 waiver.
Plus,
but even if there is no
arbitration.
Quantification I'll deal with.
How?
My lord, it's, my lord, if your lordship sees, it will come from this. Quantification is essentially, they've worked out the number, jointly they've worked out the number of days delay for which the respondent is liable. It comes out that 68% of the delay, 68%, my lord, is the delay. So therefore, they've worked out what is, my lord, the cost overrun. No, that was the claim presented, and my lord, there's a discussion.
Statutory arbitrator, is it not?
Yes. And 2 claims rejected.
Maybe. But how does he arrive at the figure? Why 23? Why not 40 as you claimed? Why not?
There's some logic to it. Even if your lordship, my lord, follows 80 Brijpal Singh's reasoning, 10%.
That's a ballpark of loss of profit.
This is a rolled up claim of loss of profit, and I'll, my lord, try and show that. As regards, my lord, no damage, I don't think they can take the issue today, having not taken it before the arbitrator. As regards interest, there, my lord, we can say this.
Why do you say they haven't taken it before the arbitrator?
Statement of defense is silent. Not raised, not argued. It's recorded in the judgment of the commercial court.
Statement of defense does not say that.
Does not take any of these no damage clauses, no interest clauses.
And how is it waived by section 4?
My lord, any right under the first part?
Arbitration Act.
My lord, even if there's no arbitration agreement, we can get out of it. My lord, section 4 really is on, if it's argued that such a clause creates an accepted matter, arbitrator had no jurisdiction to enter into these claims. Now, I'll place it, Lord, waiver of right to object. Any party who knows that any provision of this part from which the parties may derogate or any requirement under the arbitration agreement has not been complied with and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period of time, shall be deemed to have waived his right to so object. Now, my lord, as regards not taking the clauses, my lord, there are two issues involved. One is a party, my lord, not raising this defense in his statement of defense, whether he can at all argue it. Second is, as regards jurisdiction of the arbitrator. Second is, my lord, waived by this. Issue of jurisdiction is waived by section 4. The first, whether if he hasn't taken the point at all, he can't ever take it again. So therefore, no damage clause is no right to raise in section 37 before your lordships today. Regards interest, Lord, there is some, my lord, there's a recent judgment which has created some confusion, but my lord, I'll try to get out of it.
Ambika.
No, Ambika, my lord, is not good law. I must concede.
No,
Manraj.
Yes.
Manraj. It's got a say. It will not.
Cited last time, Lordship.
Yes, my lord, Manraj, my learned friend correctly cited it.
There are two Ambikas of Justice Mathur, and then a third one of Justice Chandrachud, which interprets paragraph 35 completely opposite of what it says. But again, that is binding on us. But that Justice Chandrachud's judgment is not seen by, I think this is Justice Shah.
Ambika is?
Not Ambika.
Yes, Justice Shah.
Manraj is
Justice Shah.
It's probably not noticed by Justice
But
Shah.
there is another issue there, my lord. Manraj looks at an earlier judgment which is only with regard to 37(1)(a) and then goes on to add 3 words while discussing the judgment, which is not there again. Then again in 2023 there is a recent Supreme Court judgment which, my lord, I must place before your lordship. That is in our favor. The law perhaps is this, that a restrictive agreement between the parties is valid until the date of delivery of award under 37(1)(a).
Yes, but post-award?
Post-award, nothing.
Nothing.
Only arbitrator's only jurisdiction is to give the rate. That is now again reiterated in 2023 and earlier judgments are also there. So I can perhaps get out of...
You'll get out of the second part of award, not the first part.
First part is, my lord...
Interest.
Yes, interest, my lord.
First part of interest will have to be annulled. The second part of interest may be.
First part of interest, I have only one defense. That is, they haven't raised this issue in arbitration.
In first part of interest.
First part of interest also not raised. The objection is not raised in the statement of defense.
In the in your statement of claim, you have claimed interest.
Yes, and my lord, I must point out.
You've claimed pendentilite interest and pre-reference interest.
Yes.
You claim that. Yes. And there's no objection that it's barred.
There's no objection. And interestingly, respondent claims interest. They've made a counter claim in the Sir rejoinder. There they have claimed interest.
No, the bar on interest is on the contractor. Bar on interest is not on the.
Milord, perhaps employer. This clause may be considered once, Milord. It's a different clause. I'll just read it. Milord, it is. The
arbiter. You are ready. What is your name, sir?
Mr. Jindal.
Mr. Jindal, you are ready to proceed with the matter. He says that you have not raised it in the statement of claim.
No, Lordship, I just will seek some time, Your Lordship.
Because otherwise we can finish it.
To that I have no doubt.
Quantification is...
That I'll try and get out of that when Your Lordship catches me on that. There's some logic.
No, even Your Lordship Hansel...
benefit of doubt
Manraj case...
Benefit of doubt, we'll come back to that. We'll come back to that, all cases. But this main point, if you're able to deal with, we could have finished it off today.
Your Lordship, let me go through, Your Lordship.
So tell us when?
Milord, whenever Your Lordship keeps it. My first trip to
Shillong.
So I'm here, Your Lordship, it's convenience of my friend.
Look, whenever your lordship keeps it, there's no convenience involved.
Very well.
We can do it on 13, 1, 3.
But no further time.
No further time.
No further time.
Surely.
All right? And if you had indicated to us that you won't be able to deal with it, then we wouldn't have taken it for a start. We've spent considerable time over it.
I'm highly obliged, my Lordship has given.
Since the appellant seeks an accommodation, let the matter appear 3 weeks hence, give a date 3 weeks hence.
21st. 21st
21st is, yes, 21st.
March.
Yes, call on the next matter.
Wait for me.
Item number 2.
Wait for some time, Mr. Chaudhary. Yes.
Item number 2.
May it please your lordship.
Yes.
This is a case, my lord, where the amendment in the conduct and discipline rule of the employees of aided school was carried out, my lord. Earlier under Rule 6, the employees of aided school or colleges, institutions, they were permitted to participate in the election or permitted to join political parties and office, my lord, subject to condition that.
You're appearing on the other side?
Yes, my lord.
Let's finish it off.
My lord.
Let us finish off the matter.
My lord, I have just filed, my lord. I've got the. I'll seek some time, my lord, for hearing.
So then, at the beginning, tell us. Otherwise, once we start a matter, we don't want to. Since the respondents seek some time, let the matter appear 4 weeks hence. Give a date.
Item number 3.
My lord, I have received one paper book pertaining to item number 4, my lord.
Okay.
5, 4 and 5 are analogous matters, my lord.
Who has you?
My lord, I have received 2 paper books, my lord.
So collect your paper book in respect of the other. Paper books in one of the matters has just been received. Let these 2 criminal appeals appear.
My lord.
Fortnight?
6 weeks, my lord.
My lord, one thing I'd like to point out, my lord.
Yes, some mistake?
Yes, my lord. The 313 statement. 313 statement. Statement under 313.
In both
My lord, in both the thing, my lord, the statement of one accused has been appended.
The others have not been.
No.
Very good. Then independently. The paper books have been recently received by the parties. Paragraph, it is pointed out on behalf of the state that the statements recorded under section 313 of the Code of Criminal Procedure 1973 are incomplete in the paper book, since it is only the statement of one of the accused which has been included and not of the other.
Yes.
Full stop. Paragraph, a supplementary paper book be prepared including the complete set of statements recorded under section 313 of the code at the trial. Such supplementary paper book be made available to the parties within a fortnight from date. The appeal will appear a fortnight thereafter. Individual orders in the two matters.
Deeply obliged.